Hello, my name is Shah Parali. I am an immigration attorney in the Bay Area, California. Our law firm, Shah Parali Law Group, deals mostly in immigration law, and that includes immigration to family, to employment, asylums, and some deportation cases. Today I'm going to talk about one very interesting subject, which are the parents' petition, and more specifically for Indian nationals. As you know, we deal with a lot of people from India, and each one has their own issues. And what we have noticed is that there are some common issues for most people coming from India who are trying to bring their parents here to the United States. Let me start with the first one, which are the most common one we get. People who are United States citizens and want to petition for their parents to come to the United States. It seems like a very simple petition actually, but the truth is that it can get very, very complicated if you don't know how to do it. I'm going to give you a few tips, but at the same time, it is always recommended to have a good attorney to help you, and our law firm has helped many, many. And if you look at the testimonials on our website, you'll be amazed at the kind of work we have been doing for people in the Bay Area and all over the United States, by the way, because we can handle immigration all over the US. First of all, before I start, the general disclaimer, everything that I'm going to tell you today is for educational purposes only. You should not act or refrain to act solely based on the information I'm giving to you. If you have any questions, feel free to call me at the office on 510-742-5887. First, let us talk about the parents' petition in itself. Because the American legal system and the immigration laws try to unite the family, they have made the parents' petition an immediate relative petition. That means if you file it within 1 year, usually you can get your parents here if they're abroad, and if they're inside the United States, the processing can go faster. Within 4 months, they can get a green card. And I'm going to tell you both case scenarios. One, your parent is in India, and you want to bring him or her or both of them to the United States. Note you have to do separate petition, one for the mother and one for the father. And here again, we're not talking about your siblings. Siblings petitions is a different story. We are talking about the parents. What you should do, first you file the Form I-130. The Form I-130 is filed with the immigration, and once it gets approved, the case will be transferred to the National Visa Center, where there's a new processing and new fees. And after that, if everything is completed, then it will go to the US consulate in India, whichever place you are, in Delhi, Chennai, or things like that. But there are steps that needs to be taken at every stage, because you need to be very, very careful how you file them. I've seen cases getting delayed for years because the wrong paperwork were filed. For instance, people think you just file the I-130, that's good enough. No, the I-130 is accompanied by a bunch of other forms, including the G325A, and also you have to put documents there to prove your relationship with your parents and that person is also your parent. And again, if you need help on that, you can give us a call at the office on 510-742-5887. One of the issues we have noticed for India is that many people before the partition between India and Pakistan, we have noticed that they don't have what we call a birth certificate. And this is where it gets tricky for India, because the fact that you don't have a birth certificate makes it very, very complicated if you don't know how to do it to get that petition approved. What we use in those cases are secondary evidence. First, you'll have to get a certificate of inavailability. That means the certificate is not available. Then you have to get secondary evidence. For example, affidavit of birth. Or also you can get ration cards, school records, all to prove that this person is your parent, is your mother or your father. And one thing also, that the last resort that you can also use is a DNA test, which most of the time they don't do unless there's no other proof in the case. And I've seen cases getting denied for genuine parents because it was not prepared well, and it gets complicated then to fix it at this point. Fixing is more difficult than actually preparing the paperwork. So for India, if you're having issues, give us a call, 510-742-5887. The other situation we have are people who come to visit their children in the United States and end up by staying. As I was mentioning in my previous videos, if you enter legally, for example, on a B1, B2 visa, which is a visitor visa, and you didn't have the intent to adjust status. This is very, very important. The intent to adjust status at that point, that means getting a green card when you were entering, you are eligible to file for what we call an adjustment of status. An adjustment of status, basically, you will get the green card inside the United States without having to leave the country. This is very, very important and very interesting. And there are few rules that you have to, few requirements that you have to meet in order to do that. What happens if you're eligible for that, you can file the form I-130 and the form I-45 and the form also I-765, where you will also get a work permit for your parent. The question many people ask me, hey Shah, why do I need a work permit for my father or my mother? They are old, they're not going to work. Well, the thing is that it's very important to put it in there. Why? Because by getting the work permit, it will allow you to show proof if you go, for example, to get the social security number, or you go and get a license for your father or your mother. Things like that. It's very interesting. It's very, very important to have it, even if you're not going to use it as employment. So always file the employment application in your package, and it's free. There's no additional fees, and we don't charge anything additional on our side to do it for you. Also, you can also look into the travel documents, which is the form I-131, which is something that you will need if you want to travel during the time your adjustment of status is being processed. I don't advise most people to leave during the process because it doesn't take long to get the green card. And two, if you overstayed more than 180 days on your visitor visa, for example, you might not be able to come back for 3 years. And if you overstay for 365 days, you will not be able to come back unless you get a strong waivers. And waivers are very difficult to obtain. And in this video, I'm not talking about waivers, so I'm not going to go into details about waivers. So the first rule, I'll just kind of recap what I just said earlier. One, if your parent is outside, your parents are outside, either your father or your mother, the petition is a little bit different, but it's the same form, I-130 first, then it goes to National Visa Center, then it goes to the US Consulate, which, by the way, takes a longer time than doing adjustment of status. Two, if they are inside United States, you can file the adjustment status right here, and the parent can stay in United States without leaving the country. And the good news I'm going to tell you is that, let's say you entered on a visitor visa, and if you enter on a visa, even if it's a 10-year visa, when you come at the port of entry, they will give you something called the I-94, for example. The I-94 is what controls, which is your status in the United States. Even if that visa expires, because it's an immediate, that status expires, you can still file for adjustment of status because this is an immediate petition, just like a spouse petition. But there is an issue with traveling. I will not advise you to travel. And two, as soon as you file it, that person, and you get a receipt, that person becomes legal in a period of stay authorized by the Attorney General. That means your parents is not illegal. You don't have to get another visas for them. You can just go ahead and let them wait until they get the green card. The step that happens first after you file the petition, if it is done properly, sometimes you will not get an interview for your parent. But more and more often now we are seeing an interview. And this is where a good lawyer will make a difference in your case. If it is well prepared, well documented by a good attorney, either it will avoid the interview, or even if there's an interview, the attorney will be able to prepare you for that interview and also go with you to that interview. A very, very important point. The attorney will be sitting by your side at that interview, during that interview process. So make sure you're hiring an attorney to do your paperwork instead of just hiring a consultant. That's my word of caution. And again, for people from India, if you have an issue, any issue with your birth certificates, or proving that this is your parent, or this is your mother or father, these are your parents, you can give us a call on 510-742-5887, and you can check our website on piralilaw.com. And I keep using the word parent, it's usually parents. I apologize for that, but I am trying to kind of distinguish between a father and a mother, but the process is the same. Well, there are a few issues. If it is a father, you will also have to show the marriage certificate, which is very, very important. So always make sure that you're preparing your package very complete, very detailed. And if you need any help, we are here to help. That's our job. Call us 510-742-5887, or you can check our website on perallylaw.com, PEERALLY law.com, or you can also check our blog, immigrationlegalblog.com. Until the next video, I say thank you for listening, and feel free to call us. And anything that I just mentioned today is for educational purposes only. You should not act or refrain to act solely based on the information provided. Thank you.